Thank you, Chief Justice Roberts. So now we come to the question and answer period of our afternoon. And so here's how I thought we would do it. Since there are 6 of you, I think I'm not going to ask all of you to respond to each one of these questions, but I might pose a question and ask 1 or 2 of you to respond. And if others of you want to jump in because you find it particularly interesting, enticing to answer this question, please jump in. I'm going to cover sort of 3 rough areas, and then we're going to have a lightning round. And so the 3 areas are sort of your legal education, and then the next is your professional development, and then life on the court. And then the lightning round is, what I hope will be fun facts. Okay, so we're going to start, as we should, with question 1. So question...
Good idea.
So here's question 1. So there are many 1Ls in the audience, and many people who were 1Ls, including all of you. So what was 1L like for you? Did you like it? How did you feel about being called on? Socratic method? Any thoughts? All right, so Justice Kennedy?
Well, law professors say we teach you how to think. My wife was a 3rd grade teacher. She teaches people how to think. The law school teaches you to think about ordinary things in a formal way. And after 2 weeks of contracts, I went down to Cambridge Square and Harvard Square, and it said apples, 10 cents. So I gave the guy a dime and took 2 apples. And he said, no. I said, well, it said apples. He said, are you a law school guy? Get out.
Sounds like textualism to me. But Thank you. Thank you, Justice Kennedy. Justice Gorsuch, you were most recently a 1L of any of us on the stage.
Sitting here today brings back memories of the first day of 1L. I don't know whether it's still done, but the dean addressed the first-year class in this very room. And
it's still done.
Still done. Dean Vorenberg at the time, followed by Dean Clark, who served when I was at law school. And I remember that day very vividly right now. And it's amazing how quickly the years pass. I was scared to death.
Yeah. And how long did that stay with you?
I'll let you know.
Anyone else have memories of 1L?
I got called on my very first class. I was the first person in my section who was called on by Abe Shays, who raked me over the coals some. And of course, I came out and I thought, oh my gosh, I was terrible, and now everybody knows I'm terrible. But it was the best thing that happened to me, because it just got it over with quickly, that feeling of like, okay, the worst has happened, and now I can sit back and relax a little bit. No, I won't be called on in that class, at least for a few days. But mostly just feel as though, there was nothing to dread anymore.
And were you right? Okay, I'm going to move on to the second. I'm going to move on to question 2. So I hope this is not a compound question. Was there a professor or a course at Harvard Law School that you particularly loved or that you found particularly inspirational? Justice Breyer?
Legal process.
I knew it.
Sachs. I said Al Sachs. There it is. I mean, people say that. You want to know what a justice of our court thinks? Ask who his professors were. I found in that course, that's the way it is.
And
have I changed my mind since? Never.
Was it the course or the professor or both?
No, it's the course, and it is the course. The reasoned elaboration on the common law side, the reasonable legislator, a construct on the interpretive side, and there it is. I mean, and I have to list as a professor combined with the course, Jack Dawson, contracts, great course. Now, Abe Shays was pretty good. He gave me the best question I ever asked in class. You know what it is? On the last day. And
You see what we go through.
Okay, in my antitrust class, I think I was teaching. He had his daughter when she was 7, and Chloe came into the back of the class. It's a pretty big class, so we were preparing for the exam, and you asked, some questions. They might be on the exam, they might not. And finally, I said, well, there was a case involving restraints on alienation, I think, from 1782, and I said, what was the year that was decided? And of course, nobody knew. I said, you're prepared for class, and you don't know what year that case was decided? My God, that's an easy question. A child of 7 could answer that question. Is there a child of 7 here? Chloe, I'm a child of 7. 1782. And I left the class. That was Abe Shays. There we are. There we are. That was law school in those days. I mean, that was
Can I just say who my favorite professor was? It was my antitrust professor, because you just heard from him.
Wait, I had Professor Henry Hart, and he taught at 12 o'clock. We called it darkness at noon. And he was a very popular professor, but very difficult. He'd say, and now that principle, no, that can't be. And we sit waiting.
Mr. Chief Justice?
Contracts was my favorite course because Phil Arita taught it. And he was my favorite professor. He was a master of the Socratic method, not in the way, the paper chase, sort of grilling students or embarrassing them, but he really would engage you, firmly, not gently, but for the purpose of getting information out, and he would bring the whole class into it. It wasn't picking on one person for the whole day, but it was jumping around, and it was invigorating. So I think he was a master of that craft, and it was not an easy craft to master.
Justice Souter?
I guess I would give a two-part answer. The first year, my first year, was also the first year and respectively I think the third year for two absolutely superb teachers who are still teaching. One was Charles Freed and one was Frank Michelman. And we knew what we had with the two of those. With respect to the reason a two-part question, a two-part answer is that there's a separate category, and that is the category of the old-timers, and the sort of the stellar old-timer in my law school years was Paul Freund, and I had actually taken a course with him in the college, and I knew that I wanted to take another course with him. And one of my great disappointments was that when I got second year, I did not get in his constitutional law class. But I had better luck the third year because I got accepted into his seminar, a year-long seminar on constitutional litigation. And I did not see it necessarily, or at all for that matter, as sort of a presage to the future, but it kind of turned out that way. But he was basically a source of general culture, as well as the subjects that he was teaching. You heard as much from Wallace Stevens and Shakespeare as you did from some judge, and he used to teach by telling the most wonderful stories. And when you brought that question up, I thought, gee, can I tell one of the stories?
Of course.
It's not too long. But I don't remember what the occasion for this was in the seminar, but he told a story about William Howard Taft. And he reminded us, or told us, that between the time that Taft was president and the time that he became Chief Justice of the United States, he taught at Yale Law School. And Taft was a great lover of college football. And whenever the Yale was playing in New Haven, he was there. He had a season ticket, or actually more. And Mrs. Taft didn't share his pleasure, but he went alone. But he, at that time, I think weighed 340 pounds, and he couldn't fit into a seat. So because he was a fair man, he bought 2 tickets because he was occupying 2 seats. And Mr. Freund told the story of Taft's arrival for the game one day in New Haven, and he got to his section, and he handed the 2 tickets to the student usher, and the usher was perplexed, and he said, "But you've given me 2 tickets, sir." And he was looking around, and Taft said, "Well, yes, that's right." He said, "The reason is that I, in fact, occupy 2 seats, and I think it's only fair that I should pay for them." And the usher said, "But, sir, these are on opposite sides of the aisle." And at that point, Paul Freund took over, and he said, "I would like to think that with Chief Justice Taft's great negotiating ability, that he would have resolved the problem by turning first to his neighbor on the right and convincing him to use the left-handed seat during the first half, and during the halftime break, that he would have turned to his neighbor on the left and persuaded him to occupy the seat on the right." And he said, "That way, you see, everyone could see the game, and each one would see it from a different perspective." And he said, "Difference in perspective and the capacity to appreciate it is very important."
So apart from the fact that you're all Supreme Court justices, you've had very interesting careers. So many of you were circuit judges. One of you was a state Supreme Court justice. Several of you worked in the Justice Department. A couple of you worked in the White House. Several of you worked in private practice. One of you was chief counsel of a Senate committee. Lots and lots of different kinds of experience. So what was the professional experience that you had that best prepared you for the Supreme Court? Justice Breyer?
I don't know that this prepares you for the Supreme Court, but I think the thing that nothing prepares you for the Supreme Court. Harry Blackman said you're going to find this an unusual assignment. But the thing that I thought in life, when I worked for Senator Kennedy, in professional life, I learned a lot from him. And I'd say the thing that sticks most is you often have a choice in life. Do you want the credit or do you want the result? And he would say, credit is a weapon, and listen. And when you see somebody saying something that you can use, listen. What a good idea you have. And then you get together. And then something happens. And if it's good, there's plenty of credit to go around. And if it's bad, who wants it? Okay? That's what he said. And therefore, it was the other senator that he pushed out to the newspaper. That's right. And therefore, he got the result. And I think whatever your profession, if you're going to work with other people, that was something I learned and I thought was valuable in whatever my future career was.
Thank you. Good. Justice Kagan?
We used to be called attorneys and counselors at law. When we graduated from the bar, we shook each other's hand and said, counselor, which sounds maybe like a youthful pomposity, but I was a solo practitioner, had people that had never been to an attorney before, did some criminal work, and it was fascinating to me how important the counseling function was. I still miss it. I can still, and it taught me that behind all these cases, they're a real person. And it seems to me it's very, very important for us to remember. You know, all those law books, Holmes said that the law books are the story of our moral life. And behind every one of those cases, there's a real person. My office was not far from the Capitol Park in Sacramento, one of the most beautiful parks in the country. And sometimes clients would come, and the question is, what would we do with a criminal charge or with the business problem? And we'd go through it, and he'd say, what should I do? I say, take a walk in the park. Come back a half hour later and tell me what to do. And a few years ago, back in Sacramento, somebody still came up to me. I said, I still remember that walk in the park. So we have to remember that the law relates to people, and that's it seems to me what helps me think about the law.
Justice Kagan, what was your?
Well, I guess the job I had that most obviously prepared me for the court was the job I had right before the court, which was Solicitor General, because all that the Solicitor General does is think about the court. Mm-hmm. And, the court's procedures, the court's docket, the way the court makes decisions, who's on the court, how they think, how they interact. So sometimes, it did seem as though all you did as Solicitor General was try to figure out how to persuade the 9 justices of the court, and now I think about how to persuade 8 justices of the court. And that seems...
You're wasting 4.
But in a less obvious way, I will say that I think that the thing that I think about most in terms of my own professional background is actually teaching. Not deaning, not scholarship, but teaching. Because a lot of what we do when we sit down and we craft opinions, what we're trying to do is explain really complicated things to people who are interested, who want to understand them, but don't necessarily have that knowledge right then and there. And these are really complicated concepts often. And how do you explain something to people who want to learn about it, who want to understand why the court is doing what it's doing? I think it's a lot like what I used to do when I would think about preparing for a class. I would come into my office and I would think there are going to be 100 students sitting out there, and they're smart and they're eager and they're interested, but they don't know a whole lot. And how do I explain all these complicated things to them? What I learned when I tried to do that at Harvard was also what I try to do on the court when I sit down and write.
We write in order to inspire allegiance to the result.
Chief Justice Roberts?
Arguing in the court, not so much for the Solicitor General's office, but for private clients. I argued about half of my cases for the government, half for private clients. And I was very proud to argue for the government, in essence, to stand up in the Supreme Court and say, I speak for my country. But it was when I was representing a private party that, frankly, I truly came to understand what the rule of law was. Because to my right, where the Solicitor General always was the representative of the most powerful force in the world, the government of the United States. And I had a client, whether it was an individual, an association, a company, and that most powerful force in the world wanted to do something to my client. And all I had to do was convince 5 lawyers that the government did not have the right to do that, and I won. And it just struck me that that is amazing, that being able to convince 5 lawyers and the most powerful force in the world would recede. And that's where I got a real sense of what people mean when they talk about the rule of law.
Justice Gorsuch, you spent a fair bit of time in private practice. What was the most influential pre-court piece of your career?
Well, can I go a
Anything.
little sideways?
Sure.
I want to associate myself with Justice Souter in recognizing Professor Freed as a major influence. I don't know where he is. But he was a generous teacher, a demanding one, full of stories of public service, inspiring in that way, and also a beautiful philosopher. His book, Right and Wrong, stands the test of time for me. I assigned it every year to my students in ethics at the University of Colorado. So a lawyer is friend. It captures the spirit of our profession to me as well as anything I've ever read.
Right.
So to answer your question, it's very hard for me to isolate any one portion of my career, whether it's having been an appellate judge for 10 years, which is a little bit like this job, though, as Justice Breyer said, this is a most unusual assignment. Private practice, very important too. Department of Justice, all of those things. But if I were to single out one thing, there's a friend of mine who teaches at Oklahoma City University. He's the dean there, and he's a professional responsibility scholar as well. And he did a study and found that most young people, everything you learn is great in law school, and it's very important. But we often imprint very heavily and get our professional sense of responsibility from the first boss we have. Right? And we take on a lot of what we learn. And in that, I am the luckiest man I know. Luckiest man I know. Not only did I have Byron White, I had Anthony Kennedy. He is rightly regarded as a model of judicial temperament and civility in our profession in a time when we need both. And I am very, very lucky to have started there. So that's my answer to your question.
That's a good answer.
You didn't always do what I told you to do when you're my clerk. You better start doing it.
Now, Justice Souter, you are the only member of the panel who served as a state Supreme Court justice. Do you think your service on a state court shaped the way you think about have thought about your role as a federal judge, as a Supreme Court justice?
I think the answer is yes, but not probably in the sense that you had in mind. I think the most valuable experience that I had as a state court justice, and for that matter, maybe the most valuable experience preparatory to being on the U.S. Supreme Court, was the 5 years that I spent as a state trial judge. And as a judge, you have a capacity to learn not only about the parties in a case, but the jurors in a case in a way that a trial lawyer simply doesn't have. One of the things, I'll just stick to one point, one of the things that I learned in the course of those 5 years was the inestimable moral value of the jurors judged in the way they went about their work. I can remember being at bar meetings, and a lawyer would say, apropos of criminal cases, well, you say beyond reasonable doubt, but they're going to do what they're going to do. I found out that was wrong. One of the things that I did invariably, with only 1 or 2 exceptions in 5 years, was to talk to the jurors after they had decided a case. And I wouldn't tell them whether I agreed with them or not, but I would answer questions from them, and I would learn a lot in the course of doing that. And I can remember a number of times in which I would go into that jury room after the jurors had acquitted someone in a criminal case, and someone would say, "Hey, don't get us wrong, Judge. We think he did it, but beyond a reasonable doubt, nah." They took their jobs very seriously. And I also had experience with a grand jury that absolutely refused to indict someone who was absolutely guilty because they believed there was some kind of a political hanky-panky going on between the state attorney general and the county prosecutor, and they didn't know what it was. But they were not going to put somebody in the jeopardy of a criminal case if there was something they should know, but they didn't. And it was both the independence of the jurors and their truly punctilious conscientiousness to follow the instructions that kept me from ever falling into that kind of cynicism that I described. And that certainly had its effect on my judgment in cases that came before me when I was on the Supreme Court. You may remember back during the earlier stages of the war on drugs, one of the sort of tactics was to try to make every significant possible issue in a drug possession case into a sentencing factor rather than an element that had to be proven. And ultimately, this issue got put before the court. I know perfectly well, because I was conscious of it at the time, that my respect for the conscientiousness of the jury and my recognition that they really did stand between the power of the government themselves, the defendant rather, that the most important consideration was not to allow anything as a matter of practice to creep in that was going to dilute the value of the guarantee of a jury trial. I wouldn't have been that sensitive without that experience. So what I'm saying boils down to the fact that my most valuable experiences for purposes of my time on the Supreme Court were the experiences in the trenches as a trial judge, seeing how things worked.
Thank you. All right, so here's a little bit of an odd question. It's a little counterfactual. If you had not become a lawyer, what do you think you would be doing today? Justice Gorsuch?
So I cheated. I looked at these questions before I showed up. And I had to think about this one for a minute, John. And then
I have no plan B myself.
Right. But then it became really obvious to me. I just thought, who do I envy? I envy fly fishing guides and ski instructors. And better yet, somebody who does one in the summer and the other in the winter. And I know people like that. And I really like their office and their work environment. So.
Okay, very good.
Right?
Fly fishing guide. That's excellent. Chief Justice Roberts?
Well, I would probably be hounding President Faust to see if I could get a position in the history department. I went to law school because there were no jobs in any history department. And it was only after about near the end of the first year of law school that I decided it might be a better option anyway. But I think studying history.
What kind of history?
Modern European history, which is what I spent as much time in college studying as I could. It's not as much fun as fly fishing. And
Justice Kagan?
Well, the only problem is, Chief Justice, you couldn't get into the president's office because I would be there first saying that I want to teach English literature and/or political thought.
Justice Kagan?
Well, that's so funny. It's 3 in a row who say we'd like to be university professors. I also majored in history, and I would have been a history professor, I think. That was when I went to law school. It was, should I go to history graduate school? Should I go to law school? Should I go to history graduate school? So same.
And
thing.
what tipped the balance?
You know, possibly a little bit of what the Chief Justice said. It seemed a much more practical route. But I think also a sense that
I think President Faust did okay.
I think also a sense maybe that I would have found, you know, sitting in the archives all day, you know, there was a sense in which I wanted what I did to matter, and to matter in the world, to matter to other people, and law seemed, on the one hand, incredibly intellectually challenging, but also a way to make a difference, which I wasn't sure being a history professor would.
Anyone else?
I will just add that the two who wanted to teach history, unfortunately, would have arrived a little late because I would already have gotten the job.
the competition would be very tough, I have to say.
Well, that just leaves you, Justice Breyer. What would you have done?
I was thinking I knew what I wanted to do when I was 7 years old. What I wanted to do is I wanted to be a baseball player in the summer and drive a garbage truck in the winter.
That's a good answer.
Yeah, most of us wanted to be teachers. We all had. I mean, I had, you know, people in these other departments saying, go to law school, go to law school. And that was, anyway.
All right, here is a two-part question. You may answer, obviously, since you're Supreme Court justices, either, both, or neither. And they may be the same question, they may be the same answer, or they may be different answers. So now I'll ask. So the first part is, who is the justice with whom you never served, whom you particularly or most admire? And who is, this is the second part of this, and it may be different, and who is the justice with whom you never served, with whom you'd most want to have dinner?
Well, that's easy.
Justice Breyer, you seem...
First answer is Brandeis. Practical, interested in the facts, wants to know the facts of the situation, understands the principle, writes clearly, and has decent values. And I admire what he did. Absolutely. Brandeis. Second question, clearly Holmes. Holmes had deep culture. He read a lot. He knew all kinds of things. He knew philosophy. He was in that group, what it was in Philadelphia, you know, with Peirce and James and the others. And he would be very interesting to talk to on all kinds of subjects.
Well, seem like good choices, and they both went to Harvard. Justice Kagan.
My first answer is the same. The only, you know what, those bobbleheads? The only bobblehead I have in my office is Justice Brandeis. So in addition to everything that Justice Breyer just said, I'll say that Justice Brandeis had, I think, this incredible sense of history of our nation and brought that to bear in the way he thought about law. But the person I would like to go to dinner with, I'm going to cheat a little bit. I never served with him, but I did spend a good deal of time with him, was Justice Marshall, who is the greatest storyteller I've ever met in my life, the greatest raconteur I've ever met in my life. If you're going to have dinner with one person who's ever served on the Supreme Court, take TM.
Thurgood had these stories, and when a justice retires, we have a dinner for them. And Thurgood got up to tell a story, and the story was that he'd been was counsel in a capital case, and was going to. In those days, they could argue an hour per side, and the attorney that hired him was an attorney from Alabama, and that attorney, who the boss, said that he was going to argue the first part of the case and Thurgood the second. So they sat down at the counsel table, and the case was called, and Hugo Black stands up and stalks out of the room, which is our polite way of saying you're recused. And so the argument went on, and at the end of the argument, the attorney said, "Now, I don't know why Hugo did that, because he's my cousin." The case, a capital conviction, was affirmed 4-4, equally divided court. Thurgood got to work and spent 2 years and got the sentence commuted. But we had never heard that story. None of us had. He was the great raconteur, a marvelous man, and as you know, we were very, very close.
And the justice with whom you...
I would want to meet John Marshall. He had a vision of a country that would be unified by this magnificent Constitution, a Constitution that can endure and that must endure for ages. We share something in common in that both of us told the presidents we'd rather practice law than serve on the court. But I would want to see John Marshall.
Chief?
Well, Justice Kennedy has stolen a little of my thunder. It would have to be John Marshall. His main biography, the subtitle is Definer of a Nation, which is exactly what he was. He is certainly the most significant political figure in our history who was not president. His decisions really did shape what the Constitution was going to mean in practice. He had a mind that could see all of the bounds of the problem at once and then sort through it. He was a brilliant writer. People don't realize that. If you pick up Marbury versus Madison, it doesn't read like the late 18th century. There's no whereases in there or heretofore. You can read it. An intelligent layperson can read it. And he was an extraordinary individual. His ability to exercise influence over the other justices who were living in the same townhouse through the force of his personality and the persuasiveness of his reasoning was extraordinary.
So is it the same answer for both dinner and...
No, dinner's easy. But Marshall was also, I think it's correct, the largest individual importer of Madeira in the colonies at that time. And he served a lot of it. And anyway, dinner's easy. David has touched on it. You'd want to have dinner with William Howard Taft. Not only, he's the only person, of course, President and Chief Justice, who's extraordinarily underrated because he is fat. And you think he can't really be a brilliant public servant, and you'd know you'd get a lot of food and it would be good.
Very good, Chief.
Justice Souter?
Well, I'm going to become part of the trend here for saying let's have fun at dinner instead of getting these serious types. And I'm not sure that you can improve on Holmes as a dinner companion, but a later example that I think would be pretty safe for a good bang-up dinner would have been Robert Jackson. I mean, he had the most marvelous sense of humor. He wrote the greatest opinion in English or American history on the subject of why he had changed his mind. I changed my mind once on nude dancing, and I borrowed liberally from his opinion on it. But he...
Keep on, David. Keep on.
I don't remember, David, which direction you went.
I went in favor of it, of course. But, and let's not end with that. Remember, as an example of Jackson's wit, he was Toastmaster, I think, at a testimonial dinner honoring both Learned Hand and his cousin Augustus Hand. He paid great tribute to Learned Hand's craftsmanship as a writer and to Augustus Hand's great wisdom and common sense on matters of substance. And he ended the toast with, quote Learned and follow Gus. I mean, that's the kind of guy to have at the dinner table.
Thank you. Justice Gorsuch?
Justice Souter has stolen part of my thunder. I would pick Robert Jackson instantly as someone I would have both loved to have served with and had dinner with. Remarkable. He didn't graduate from the Harvard Law School, or really any law school, right? I mean,
Then it's okay.
and that's okay. Practiced for a number of years in upstate New York, and then serves in every important role in the administration, and then becomes a judge, and then often rules against the administration he just left as Attorney General, and recognized the difference in function between judge and advocate, and spoke about that beautifully, as he did what it means to be an official of the Department of Justice, that beautiful speech. And then, of course, Nuremberg. I mean, 20th century life as a judge, I just think it was just such a pity his time was cut short. And then I'll throw in another one, because I'd agree with so many others that have been mentioned, but maybe one that hasn't been mentioned was Joseph Story. Really a scholar of the Constitution, someone who did do it all. He was a scholar and a thoughtful judge. And the quote that we heard from the president from his work gives you a sense of the man's heart and mind, and I just very admirable, capable of both being carefully analytical, but also understanding the consequence and the weight of his role.
Thank you. Those are great answers.
John, I'm going to give away one of the amazing things about being dean of Harvard Law School. Is you sit in this office, and there are two desks in the office, and one of them is Justice Story's desk,
Right.
and the other is a stand-up writing desk, which is Justice Holmes's desk.
Well, we now call it the Story Kagan desk, actually.
Well, if that doesn't give you a sense of responsibility and a sense of the importance of this institution and what it does in the world, I don't know anything that would.
Thank you, Justice Kagan. All right, I'm going to ask a couple of questions about your work now. So, here's one. What qualities make for a great lawyer, either before your court or anywhere? Second is, what are the most common avoidable mistakes that lawyers make in briefs and oral arguments? Justice Kagan, you've been a teacher, a solicitor general, a justice.
I think there's no one set of qualities that makes for a great lawyer, because I think there's so many different kinds of lawyers in the world. And I think the qualities that make somebody a great lawyer in our court are very different from those that make somebody a great trial lawyer or a great negotiator. So I think that one is all specific to the situation. What makes for a great Supreme Court advocate, I'm going to say the Chief Justice should tell you that, because he was one of the greatest that ever lived. But I think it's the ability to really engage in a conversation with the court, not to ever run away from questions, to understand that the hard questions that they're asking you are the ones that you have to answer to prevail. To be respectful, but also to approach the court as an equal. You're explaining things to them. You probably understand the case more deeply at that point than they do, to have confidence in yourself. But always, always, always to listen to what the judges are asking and to go with that, not to give any kind of, I have 10 points in my pocket that I need to get to, but to listen really carefully to the bench and where it's at, because that's who you need to convince.
Does that sound right, Chief Justice Roberts?
Well, Justice Kagan, one of the greatest deans that has ever lived. I agree with pretty much everything she said. I try to sum it up in saying that the lawyer must be dispassionate. And I think this is true not only in arguing before the court, but in negotiation. I don't know as much about trials. In other words, you have to have the judge think that you are not just, pounding away zealously for your client. And there are ways to do that. One is that you recognize the weaknesses in your case. When the judge or justice says, well, what about this case? Don't pretend that it's not bad for you. You can say, well, that's not our favorite case, and here's why. But you go on to explain. So the judge feels that you're part of in the same role to some extent with her, in the sense of trying to figure out the case. And once you can establish that relationship, you can be a much more effective advocate.
So it sounds as if listening, candor, answering questions all work very well. And anybody have a different view? Is that what you all look for?
I've not been really a practicing lawyer except for a couple of years in the Justice Department. But over time, I've met many lawyers, and I admire quite a few. And the qualities I admire are things that you brought out. You're no stronger than your weakest argument, not your strongest. But the thing I think I admire, Lloyd Cutler and others who have that, I heard it put, Bill Coleman, it was a quality that actually Drew Faust mentioned, a certain disinterestedness. You're for your client, but not too much. And that's right, you step back a little. And those I admire particularly. They've spent quite some of their career anyway in public service, not entirely private. You're part of the community, and there's so many ways to be part of the community. So I like those $1 a year, used to be men, now women too, or on the library board, or whatever. But the lawyer is part of a community. The lawyer is representing his client well, but remember that disinterested, that's a good word, and you're no stronger than your weakest argument. Make sure you understand that.
And so it sounds like an issue of trust, that the lawyer needs to build trust. Mm-hmm. Justice Gorsuch, what do you say?
Well, I was in practice predominantly a trial lawyer, and I think one thing that everything that's been said remains true for the trial level as well. But two other things I might add to the mix. One is just plain old hard work. It's tough to be a lawyer today, and teaching young people. Those nights in Langdell, they pay off. They're worth it. To know the law, to be able to serve your client well, requires a certain irreducible amount of hard work. And the other is ethics, lawyer as friend. What does it mean to be a friend to your client? It means giving everything you've got without giving up yourself either, and what's essential to you. So your integrity matters a very great deal in the process.
Thank you. Anyone else want to?
Well, when sometimes people at a social occasion say, does oral argument make a difference? And they stand back like they've asked you a trick question. Because if you say no, you're engaging in a charade. And if you say yes, you're being pushed around by a bunch of lawyers. But of course it makes a difference. And as my colleagues have indicated, we are there in order to make up our minds, and this is, and as Justice Kagan and Justice Roberts indicated, a good oral argument, if sometimes we behave well, sometimes we don't. A good oral argument is a conversation that justices are having among themselves that the attorney can enter into. And I agree with Justice Kagan. You really want to help the judge and try to enter the justice and enter into his or her mind, because that justice is trying to decide how best to understand your argument.
Thank you.
Can I add one thing?
Of course.
A detail. As several people have said, starting with Justice Kagan, listen to what the court is saying and try to respond to what is really on the court's mind. And the one point of detail that I might add to actually to the Chief Justice's follow-up is that a very good way to do that, which not that many lawyers, I think, practice, is to sort of structure your argument by going back to first-year procedure. Remember I don't know whether it's still taught this way, but it was when I was first year. We learned the old, something about the old forms of action and the old formal pleas, one of which was a plea in confession and avoidance. And you say, yeah, everything that they allege is true, but it does not amount to an actionable violation or whatnot. And the master of responding to what is really on the judge's mind, to what the judge clearly indicates is the stumbling point. The master doing that was Rex Lee. And I never heard Rex Lee when he was Solicitor General, but after he had resigned from that, he argued several cases when I was still on the court. And Rex Lee, I don't know whether he did this consciously or not, but it sounded that way when you'd see it demonstrated. He was prepared to give a confession and avoidance answer to the most devastating question that a judge could ask him. And he seemed to structure his answer in that way. And I remember one day and by the way, when I was on the court, I always sat next to Justice Scalia. And I remember one day, I don't remember the case, but I remember one day when Rex Lee was arguing, and Justice Scalia asked him the ultimate question, and the case was going to be won or lost, at least in Justice Scalia's mind on that. And I happened to watch Mr. Lee's face as Justice Scalia was asking the question. And he didn't totally suppress a little flicker of a smile. And I remember when Justice Scalia finished, Rex Lee pointed at him with his hand, and he said, "You're dead right, Justice Scalia, and I'll tell you why it doesn't make a bit of difference in this case." So if there is one pointer that I would add to the discussion is, don't forget confession and avoidance, because it's a great way to organize your capacity to survive the devastating question.
Justice Souter does not remember the losing lawyer in that case.
Pardon me?
You're not remembering the losing lawyer in that case.
I thought it was polite not to.
And it was 9-0. So thank you.
All right. I think we are down to our last 15 minutes, and I think we have time only for the lightning round. So I'm going to ask a question, and if you recognize yourself as the person I am describing, please raise your hand and say a few words about this fact.
Is this confession and avoidance?
I think that's up to you. All right, ready? First one.
What happens if no one raises their hand?
Then I will call on you. All right. First one is, one of you was an Eagle Scout by the age of 12. Eagle Scout by 12. Justice Breyer.
Can you tie a knot?
Can you tie a knot?
Can you tie a knot, Stephen?
Yes.
Yes.
I never heard of
Full
anybody who was an Eagle
she
Scout
changed-
at 12.
What?
Yeah,
12?
How did it happen?
Yeah.
How did you do it? And
I
is
began at 8.
You began at 8?
Yeah, I lied about my age.
Fair enough. All right. One of you worked on oil rigs in Canada and Louisiana. Canada and Louisiana oil rigs. Justice Kennedy.
Right. My uncle was in the oil business, and my first job in Canada was I had to nail up what we call a doghouse in the oil field business. And I had my new overalls and my gloves, and I nailed the boards up because the foreman was coming over, and I nailed my glove to the wall. I couldn't get it out, so I tore it out, and I said, "Don't worry, I'll get it out." He said, "Oh no, you leave that right here." So all summer long, every salesman that came out there had to see the glove. But then I got to know the oil fields and worked on drilling rigs to help pay my way through college.
Interesting. Okay. One of you was a member of the United Steelworkers. Chief Justice Roberts.
Electrical helper job class 6, I think is what it was, which meant you walked around with the electricians, and whenever they wanted some fun, they'd tell you to tighten a particular bolt that turned out to be live, like this. And it just never got old for them.
All right, now this is a very good one. One of you engaged in a mock sword duel during your second year at Harvard Law School and ended up at University Health Services.
You know, it was a way to pass the time. By the time I did this with one of my classmates, I was also a proctor in Harvard Yard, freshman proctor. And so we got the ranking assistant dean of freshmen to referee the duel, and probably most of my freshman proctees showed up for it. And everything was going fine, except for one problem I had with the sword. Mine did not have one of those guards that goes over your hand. And my friend's saber came down, against the side of mine and smacked right into the sort of the joint in the flesh there, and the thing started bleeding. And my first reaction was to just let it bleed, but my boss, the dean, looked at it and he looked at the saber and he said, the thing is dirty and rusty. He said, it's probably crawling with tetanus. You better go down and get a shot. So the entire entourage traipsed down to the University Health Services, and while we were waiting for a doctor to come out, a lot of the freshmen had come, and I began to think, I've got to be hospitable about this. So we were, the UHS in those days, maybe still now, was right across the street from Elsie's restaurant on the corner of Mount Auburn Street and Holyoke. And Elsie's served a great cream cheese and caviar sandwich. So I gave some money to one of the freshmen and said, you know, go over and get whatever we had at that point, 12 cream cheese and caviar sandwiches so people can enjoy themselves while we're waiting. And, you know, finally a doctor came out and he said, well, how did this happen, sir? And I said, well, I was fighting this duel, and he said, and I think he began to lose professional interest at that point. And at just about that moment, the kid arrived with the cream cheese and caviar sandwiches, and that ended the patience of the University Health Services. They told everybody else to get out, and they did give me a tetanus shot, and, you know, it worked.
Justice Breyer, you have a comment on
things happened to him. Honestly, while he was a active member of our court, he's walking in the woods somewhere, a rabbit jumped on his back and bit him in the neck. That's right. And then, by the way, when he's in his office, he finds a fox that came out of the basement.
We're learning a lot.
We miss you, Dave.
All right, next question in the lightning round. One of you has raised horses, chickens, and goats. Justice Gorsuch.
Yes, no foxes. Yeah, my daughters were huge into 4-H, and I learned how to bathe a chicken, which is not something I recommend. And raising a goat, I definitely don't recommend. But we attended more 4-H events than anyone should in a lifetime. And I loved every second of it. Yeah.
And one of your former clerks, I won't identify who, said that your goat thought it was a lapdog.
It Nibbles the goat, aptly named, was an escape artist. He would get out of the corral, proceed to eat most of our fruit trees bare, and then work his way in the house, and thought he was a lapdog. Yes, that is all true. And was vaguely housebroken by the end of it, but not quite. You don't want to go. Yeah.
Okay, so now we're almost done with the lightning round. A couple more questions here. One of you uses contractions only in dissents. Justice Kagan, would you care to elaborate on that?
You know, when you're writing for the court, you should be a little bit formal in my view. But when you're writing for dissent, you can let it go a little bit more. Letting it go here being equivalent to using contractions.
All right. One of you was caught by the dean of the Harvard Law School at a Red Sox game the day before a tax exam.
It was 1960, the last year Ted Williams was going to play, and I was going back to California, so I wanted to see him. And so I told my study mate, I said, I've got 2 tickets. I was really worked on them for the Boston Red Sox. He said, well, the tax finals tomorrow. And I said, well, you bring the revenue code, I'll bring the case book. And we sat down, and I heard this voice saying, you don't bring the revenue code to the baseball game. and it was Erwin Griswold. And he was shocked. I don't know if he thought it was a profanation of the code or of the game. But he would see me like 20 years later in the court and said, do you still bring the revenue code to the baseball game?
All right, this is a question for which two of you need to raise your hands. Two of you have often been confused for each other at oral argument and once by an O'Connor clerk.
And we don't know why. Actually, it just happens all the time, my favorite sort of summation of the problem we have came, if I get this wrong, correct me, came at one of those lunches that Justice Breyer was having with law clerks from other chambers. They would invite us to lunch and so on. And one clerk decided to sort of broach this subject and said, as I understand it, I understand that you and Justice Souter are often confused. And then realizing what he had said, he said, I mean, you get all mixed up.
But one of you has to tell the story about the best thing about serving on the court.
About the what?
The best thing about serving on the court?
Yeah, I think it must be exaggerated. Unless it's,
The
but
story-
I do get asked. You mean I'm a member of the court? And people ask.
No, this was a great response you had, David, to the
What?
confusion.
Oh, yes, in Jake words. In Jake words.
No,
Do I have to
Jake
tell the
words.
story
I told
for
you
you?
a story. You tell mine.
No, it's your
Go
story.
on, you tell it.
It happened to you.
You tell
I
it.
just make it up.
It's
Oh,
about
well, I'll
you.
tell it. It's a true story. Somebody tell the story. Someone comes up to Justice Souter, mistakes him as Justice Breyer, and asks, Justice Breyer, what is the best thing about being on the Supreme Court? And David said, serving with Justice Souter.
That story, by the way, has been called Truthy.
It works.
All right, last three questions. One of you, as a Harvard law student, went to Harvard Square almost every day for 31 flavors. 31 flavors. Chief Justice Roberts, would you care to elaborate?
It's like the episodes of Friends. You like to go someplace where you're known, where they know your name. And the Baskin-Robbins store, they knew my name. And you would go in and it advertised 31 flavors, but I always had the same thing. So.
What?
No, it was a marshmallow sundae with chocolate chip ice cream.
Wow.
It's good.
All right, the next question. One of you celebrated the end of the first term of service on the Supreme Court by not shaving all summer. Justice Gorsuch, how did that work out?
I went home to Colorado. I hiked 14ers, fished, and did nothing. I haven't had a summer off since I was 12. It was fantastic. It was wonderful. I did grow it out all summer, and then I asked my daughters whether I could be seen on the bench. And they said, under no circumstances whatsoever. And my wife said, oh, they'll start reading into it. What does the beard mean? So off it came, and yeah, I did.
All right, final question. One of you was voted by your fellow law clerks to be the clerk most likely to serve on the Supreme Court.
Well, I know who must have told you that embarrassing fact, because Professor Steicher was...
I cannot confirm or deny that.
I'm just going to say Professor Steicher was my co-clerk, and at the end of the year, we voted each other all these, you know, sort of yearbook categories. Professor Steicher's, she was going off to be a public defender, and she was voted the last person to make $1 million. And this was, mine was, it was definitely better than being voted the first person to be indicted.
I won't ask who that was. Let's give a big round of applause to the justices.